So today we'll be discussing two important provisions under the Indian Patents Act which relate to appeals as well as revocation. So in case you get an adverse decision in respect of your patent application from the patent office, you have the option of filing an appeal. Under the revocation process, you can file a petition challenging the validity of a patent and ask the authority to revoke that particular patent on various grounds that are provided under Section 64 of the Patents Act. Also, the appeals are provided under Section 117A of the Patents Act. We'll also see where these appeals and revocation could be filed in view of the latest amendments that have happened in respect of the Tribunals Reforms Act 2021. So appeals are provided under Section 117A of the Patents Act. In particular, Section 117A subsection 2 provides that appeals would lie against any decision, order or even direction of the controller of patents in respect of particular sections. For example, Section 15 relates to any refusal order that the controller may have passed after examination of the patent application, or maybe he might have required you to amend the specification, after which only the patent could be granted. So you could challenge that particular order of the controller under Section 117A. Section 16 relates to division of application. We have already discussed that provision in one of my videos. Section 17 pertains to dating of an application. Again, I've made a video on that particular provision. You could go to my channel and see that. Section 18 relates to any order passed by the controller in case he finds that your patent application or your invention is anticipated. Section 25 subsection 4 relates to any order passed by the controller of patents in respect of an opposition proceeding that may have been carried out. Section 54 relates to patent of additions. Section 57 relates to any amendments that are carried out to patent applications. I've also posted a video regarding that. You could go to my channel and have a look at that. Section 60 pertains to restoration of any lapsed patents for which maybe you may not have paid the annuity and then the patents lapsed, and any orders passed in that respect, you could challenge that. Section 66 relates to revocation of patents in public interest. So in case there is an order passed in that respect, you could appeal it. Section 78 relates to correction of clerical errors. Section 84 relates to compulsory license. So any order passed by the controller in respect of grant or refusal of a compulsory license could be appealed here. The remaining provisions marked here relate to compulsory license, and I've already made a video on all these provisions. You could go to my channel and have a look at what these provisions include and what could be the possible orders that may be passed which could be appealed. Section 117A subsection 4 provides that an appeal is to be filed within 3 months from the date of the decision, order or the direction as the case may be. An interesting development that has happened recently is that prior to April 4th, 2021, the appeals used to be filed before the Intellectual Property Appellate Board. But now with the enactment of the Tribunals Reforms Act of 2021, the IPAB stands dissolved, and thus any appeals against any order under 117A could be filed before the High Courts. Also, consequent to enactment of the Tribunals Reforms Act, Section 117B, 117C, 117D, F, G and H stand omitted. So I'm not discussing all these provisions. The procedural aspects related to filing of appeals have been provided under Delhi High Court Intellectual Property Rights Division rules. These were released in February 2022 and define the procedure for appeals. Format of appeal is provided under Schedule 1 of the rules. The appeal documents should necessarily include the memorandum of parties, what are the parties that are involved, a brief synopsis of the case, a list of dates, and a brief memorandum of the appeal as to what are the basic grounds, the basic facts in respect of which you are filing the appeal. You have to include the order that you are challenging and also an affidavit of the appellant. So under the appeals procedure, there is no provision of recording of evidence unless and until the court deems it necessary. Evidence may particularly relate to technical experts or even legal experts, where the court may require such experts to in a way provide their opinion on a particular aspect which the appeal is dealing with, or maybe some technical aspect relating to the invention. So in case the court deems it necessary, it could ask for such evidences to be submitted. Again, the opposite side is required to file a reply only if the court directs. Further, what used to happen before the IPAB was patent agents or trademark agents could appear and argue their matters, but before the courts, patent agents and trademark agents as such cannot argue the matter. It has to be only done by legal practitioners or counsels, but patent agents or trademark agents could appear alongside the counsels and aid them and also the court in that particular matter. Further, any appeals against the order of the IP division of the court, where you have filed an appeal and maybe the court gave a decision in respect of that particular appeal, could be challenged under Section 13 of the Commercial Courts Act. So since you are before a single judge, now the appeal would go to the division bench. Revocation is provided under section 64 subsection 1. It says that any patent could be revoked by a high court on a petition that is filed by an interested person or in respect of a counterclaim in a suit for infringement. So maybe there is a patentee who has filed a suit for infringement and the defendant wants to challenge the validity of the patent and say that since the patent is not valid, there is no question of infringement. So he would file a counterclaim. He could challenge the validity of the patent under section 64 in a counterclaim in a suit for infringement, or else there could be a separate petition filed by that particular person or any person who is interested in getting the patent revoked, and you file a separate petition under section 64(1) before the High Court. Now, under the revocation petition, one could rely on various grounds which are provided under section 64. I will be discussing all these grounds very briefly. So one of the grounds is that the claimed invention in the patent sought to be revoked was already claimed in another Indian patent of an earlier priority date. So there is no uniqueness in the patent which is sought to be revoked. Another ground is that the patent application was made by the person who was not entitled to apply. So maybe the applicant did not have the rights to apply for a patent and still he went ahead and filed and then got a patent on it. But now you could revoke it on the grounds that the applicant was not entitled. He did not have the right to file this particular patent application. Maybe the inventors did not transfer their rights to the applicant who filed the patent application. Yet another ground is that the patent was wrongly obtained from the petitioner. So in a way, the petitioner was the true creator of that innovation, but the applicant wrongfully obtained that innovation from the petitioner and filed it in his own name. So in that case, you could petition the High Court to revoke the patent. Another ground is that the subject matter of any claim does not qualify as an invention within the Act. So if you refer to the definition of invention under section 2(1)(j), so any particular claim of invention, or maybe all the claims, do not fall under the definition. So maybe it's not a defined process, or it's not a defined product, or maybe it doesn't have novelty, inventiveness, and industrial applicability, or any of these. A related ground is that the claimed invention is not new, which means that it is anticipated in view of some prior public knowledge or prior public use in India, or maybe prior publication in India or elsewhere. Yet another similar ground is that the claimed invention is obvious or does not involve an inventive step in view of what was known in view of prior public knowledge or use in India, or a prior publication that has happened in India or elsewhere. However, for both these provisions, an exemption is provided, that is a disclosure in a personal document which is not in public domain, which no one has seen, would not be counted as anticipation or would not be considered for an obviousness issue. Also, any secret trial or use of the innovation for the purpose of maybe evaluating the effectiveness of the invention would not be considered as relevant for affecting the novelty as well as inventiveness of the innovation. Also, a patent could be revoked in case the claimed invention is not considered as useful. So while there may be fixed criteria for determining when an invention could be considered as novel or inventive, but I believe for this last provision, to determine whether an invention is useful or not would require a very high burden of proof on the petitioner, because he'll have to prove that how the invention is not useful. Yet another ground for revocation is that the complete specification of the granted patent does not sufficiently describe the innovation or the method by which it is to be performed. So in one of my videos related to section 10(4), I had specifically mentioned that the complete specification should sufficiently and completely describe the innovation. So in case you are not doing it, your patent is liable to be revoked. Further, in case the scope of claim is not clearly defined, or it is not based on the matter which is disclosed in the complete specification, if it is beyond the scope of that, then your patent could be revoked as well. In case the patentee has obtained the patent based on some false suggestion or representation that has been given, maybe some facts have not been correctly stated, or maybe some information has been provided wrongly, then the patent is also liable to be removed. Also, in case the subject matter of the claimed invention is not patentable under section 3, then also a patent is liable to be revoked. Also, if there was a prior secret use of the innovation that is covered under the granted patent, except for the purpose of a reasonable trial or experiment, or maybe used by the government or on behalf of the government, or in case the patentee had made any disclosure to the government, say for getting some permissions, some regulatory approvals, or maybe there was a communication or disclosure of the innovation revocation without the consent of the patent applicant. Then such prior use are exempted, but any other prior secret use would make the patent liable for revocation. So put it simply, any prior secret use except for the exemptions that are provided here would qualify the patent for a revocation proceeding. So just to briefly define what could be a reasonable trial, so sometimes there are innovations which could not be commercialized unless and until a trial of the finalized product is carried out in the public or maybe on particular group of people. So if there is a prior use of the innovation on such group which is secret, then you are exempted, and if you file a patent later on that particular innovation, you would fall under this provision and your patent would not be revoked, at least on this ground. Another important ground is that in case there is a non-compliance of section 8, or if the information that was submitted under section 8 was false, then also your patent is liable to be revoked. However, this provision has been substantially diluted by the High Court in few decisions, and I have also made a video on this particular provision and how it has been diluted by the High Court. You may have a look at that particular video to understand the scope of this particular provision. Also, any contravention of secrecy directions under section 35 or section 39 would make the patent liable for revocation. So if you want to see what these provisions, section 35 and section 39 entail, I've also made a video on these provisions. You could have a look at that. In case any amendments have been carried out under section 57 or section 58 and those have been obtained under fraud, then the patent is liable to be revoked. Moreover, in case of a non-disclosure or in case the patentee has wrongly mentioned the source or geographical origin of a biological material that has been used in the innovation, then also the patent would be liable to be revoked. The last of the ground deals with traditional knowledge. So in case the claimed invention is anticipated by any knowledge that is available with local or indigenous communities, then also the patent is liable to be revoked. Section 65 and section 66 provide some other grounds based on which a patent could be revoked. So if an innovation relates to the topic of atomic energy and those subject matter which are covered under section 20 subsection 1 of Atomic Energy Act, then any patent that has been granted could be revoked on directions of the government under section 65. Additionally, in case there is an innovation which is mischievous to the state or generally prejudicial to the public, then also that particular patent could be revoked in public interest. An important thing to note here is that the revocation under section 65 and section 66 happens at the patent office level, while the revocation under section 64 happens before the court, and that is the reason any appeal against revocation under section 66 would lie before the High Court. So coming now to the procedural aspects regarding revocation petitions, these are to be filed as civil original petitions under the Delhi High Court IPD rules of 2022. The petitions are to be made as per Schedule 1, and the petition should necessarily include a memorandum of parties, which are the parties involved, a synopsis of the case as to why the person is interested in revoking the patent and what are the grounds he is relying on, the list of dates, and also the affidavit of the petitioner. The IPD rules provide that the petitioner could seek interim reliefs under Order 39 Rule 1 and 2 of the Civil Procedure Code in case that is required. Also, along with the revocation petition, you need to file the complete specification of the patent and also the relevant forms that have been filed at the patent office along with the patent application. Moreover, evidence is to be filed only if deemed necessary by the court, as it was in the appeals procedure. Also, in case the revocation petition has been filed suit and there is an already existing infringement suit, then the court may ask for consolidation of the proceedings of the infringement suit as well as the revocation petition. So what may happen is a patentee has filed an infringement suit, and instead of filing a counterclaim, the petitioner has filed a separate revocation petition. So now if this fact is brought to the notice of the court may want to hear both the proceedings together, and thus the court may ask for consolidation of the revocation hearing along with the infringement suit, so that the validity is decided and then the court may go on to deciding the infringement aspect. So recently there has been a decision of the Delhi High Court in which it was decided as to which High Court you should file an appeal or a revocation petition. So it defines the jurisdiction of which particular High Court you need to approach. Very briefly, the question arose because the patent application was filed in one particular patent office and it was examined in the other because of the administrative arrangements that the Controller of Patents had done. So maybe if the application was filed in Mumbai, it was examined in Chennai. So if a refusal order has come from the Controller, seller who was based in Chennai, where would the appeal lie? Would it be in Chennai High Court or whether it would be in the Mumbai High Court? Also, in respect of revocation petitions, whether the revocation petition needs to be filed in the High Court where the petitioner resides or maybe where the patent has been granted. So these were the questions that the High Court was dealing with, and after going through the entire process of arguments and referring to the material that was cited by the two sides, the court decided that the appeals are a continuation process of prosecution of the patent application, and thus the definition of appropriate office holds importance. So appropriate office has been defined in Rule 4 of the patent rules. Based on where the applicant is residing, you decide the jurisdiction of the patent office where you are filing the patent application. So that holds importance in case of an appeal, and wherever you have filed a patent application, that is the appropriate office, and thus any appeals are to be filed in the High Court that has territorial jurisdiction over the appropriate office, irrespective of where the hearing was held. So hearing may have been held in Chennai, but if the application was filed in Mumbai, you have to file the appeal before the Mumbai High Court. However, for revocation petitions, the court decided that the jurisdiction of High Court is to be decided based on the static and dynamic effect of grant of patent. The static effect of grant of patent is where the patent has been granted or filed. So dynamic effect of grant of patent is that a patent may be granted in Mumbai, but it has India-wide approach. You could use that particular patent to stop a person who is selling his product in Calcutta. So this is dynamic effect, even though it has been granted in one particular area, but it has overall effect over the entire territory. So that is the dynamic effect. It has a wider scope. So the court said that a revocation petition could be filed before two types of high courts. One, which has the territorial jurisdiction over the place where the patent was granted. So this is the static effect. Also, a revocation petition could be filed before a high court of a place where the commercial interest of the petitioner lies. So if the petitioner, he's carrying out his business in Calcutta and that is where his business is being stopped, there is the cause of action, and thus a revocation petition could be filed before the High Court of Calcutta. So this is how the court has provided clarity regarding where you need to file appeals or a revocation petition. So this is all about appeals and revocation. In case you have any questions or any specific comments, please drop them in the comments box and I'll be happy to answer those. Thank you very much.